Welcome to Celebrity Estate Battles That Can Happen to You and How to Avoid Them. I am attorney Lisa Haster. I'm happy to be with you here today. I am an expert in asset protection, a legacy lawyer, and a published author. And I want to jump right into it because this is a fun presentation, you guys. I want to see if as we go through this, you can spot the errors that some of these celebrities made and think about ways that when you're putting together your legacy plan, you can avoid these same errors. I'm going to start by telling you a story. Now, this is a story about a man who goes into a bar. This is not a joke. This is a true real life story of a man who walks into a bar, and he's not a particularly good looking man. He's middle-aged, he's balding a bit, and he's a shorter guy, a little bit on the heavier side. But he decides when he sees this beautiful woman across the bar that he's going to make a play for it. It's now or never. And she is this gorgeous, curvaceous blonde. And he beelines across the bar to introduce himself. And he says to her, "Hey, now I know I'm not a good-looking guy. I'm not a wealthy guy. I'm not in great shape, but there is one thing. There is one thing that could draw you to me. My father is a multi-billionaire, and he is only supposed to live another 3 to 5 days." Well, as you can imagine, she was intrigued. And he sparked her interest so much that just 3 days later, she actually became his stepmother. That is right. And let's see if I can figure out how to get, there we are. Anna Nicole Smith was the smitten kitten across the bar that this gentleman had his eye on. And just 3 days after meeting Mr. J. Howard Marshall, the oil tycoon's son, Anna Nicole said I-dos to his father and became his stepmother. What is the lesson here? The lesson here is to steer clear of gold diggers, right? And be prepared for memory loss and incapacity that can go along with an aging person who makes poor and spontaneous decisions, all right? So the lesson from Anna Nicole Smith is prepare for the uncertainty of memory loss and incapacity and prevent opportunists from gouging down your life legacy, your estate. You might be wondering, what exactly is an estate? And an estate is an accumulation of all of your assets. And you get to decide how they're distributed when you pass, or alternatively, if you do nothing about it at all, the courts will decide for you, and that'll be left up to opportunists, Uncle Sam, meaning the IRS, who can all swoop in and try and get at your money, okay? What makes up an estate? Retirement accounts, your personal tangibles, your valuables, bank accounts, brokerage accounts, any real estate that you might have, including your home, life insurance policies, investments, and any business interests that you have. All of these things combine to make up your estate. Let's take a lesson from Prince, shall we? There we go. Good old Prince. It's no surprise Prince died without a will. He sang the song, "I Will Die For You," and then he died without a will. Ironic, isn't it? Prince passed away in early 2016. And as we sit here today, this is being filmed in the mid part of 2020. Prince's estate is still open because he failed to take action. He failed to put a plan together. What that means is that his estate was forced to go to probate court in order for a judge to determine how his assets were going to be valued, how they're going to be split up and then distributed, and who his heirs at law, or those who are entitled by law to receive distributions from his estate, who are those people? And it has been in litigation, so in probate court, for over 4 years now. And as you can imagine, these lawyers they don't work for free, okay? They want to get paid, and they are getting paid heavily, and much of those lawyers' fees are coming from Prince's estate, so that estate is being drained down in funds every day that this matter is being litigated. So here's the problem with not having a legacy plan or an estate plan. You make the same mistake that Prince made. Dying without a plan means that you are going to relinquish control of your assets. Instead, your assets and your kids need to be managed by a court. A court will make all decisions because you failed to do so while you were still living. And that means that all of your assets and your debts have to be published. By law, we attorneys, when we take on someone's estate, we are required to show the court that we have published for a minimum of 2 weeks all of your assets and debts and the fact that you've passed, to give people, businesses, companies, anyone who thinks they're owed money, an opportunity to bring a claim against that estate and start an action. So you can imagine if you've got an estate the size of Prince's, what a complete mess this is creating. All right, it allows anyone to make a claim for money, really anyone. And you heard in the Prince case, there were all kinds of people coming out of the woodwork, a guy in prison claiming to be Prince's son. So, you know, we're 4 years in, this might go on another 4 years and possibly longer until it gets sorted out. So we're talking about years and years, right? And it's years even for an average person. If, you know, I see clients all the time who only have several $100,000 in total assets and they don't do any planning. Their children then come to me after they pass and say, what do we do? And I say, well, you're forced to probate the estate before the court. So we bring that action, and even when those kids are all getting along, it's uncontested and there are no claims made against the estate, I am looking at a minimum of 2 years before that estate is closed by the court. And this is draining the money, right? The funds from the account. It's just taking money away from you know, what could have gone to your loved ones. And instead it's being used to fight these crazy battles. So 4 things that I always tell my clients are going to force an action into probate if you don't have a trust. And we'll talk about trust here in a second. But the 4 things, if you die without a trust and your estate is forced to go to probate court, these are the 4 things that are going to get you there. Having minor children. Now, you might think that you chose guardians for your children because you told your sister-in-law, if anything happens to me, I want you to take over and I want you to be the legal parent. It doesn't work that way. If you don't have a trust, it's going to go before a judge, and the judge is going to decide who raises your children, regardless of your intentions, because there's a standard that the judges are required to apply, and that is in the child's best interest. And what you think the child's best interest is your parenting values, those don't always necessarily align with what looks good on paper that the judge has in front of he or she when they're making a determination. So you might have said, I want my sister-in-law, but it might turn out that your older sister, who's a train wreck and who's, you know, got children who are in and out of rehab and is in a horrible marriage with her spouse, on paper, that person might have better credentials. And so the judge might decide that, in fact, despite what you told your sister-in-law or what you've got in your will, that they believe this person's a better choice to raise your children. So if you've got minor children, you've got to get your intentions into a trust. The second thing that's going to force an estate or your legacy plan into probate let's see if I can move myself again here, are if you have total assets over about $75,000. And now this varies from state to state. This happens to be the Minnesota as of 2020. But we're not talking about much here, people. This is why it's a complete fallacy. There's a misconception that you have to be extremely wealthy in order to do legacy planning, and that is absolutely not the case. If you've got total assets, and that includes your home, of over $75,000, your estate will be forced to probate unless you build a trust. Third thing, if you have creditors, again, creditors can jump in because you have to publish, in fact, that you've passed away, and they can come in and make a claim and seek repayment from the estate. Finally, if you own any real estate at all, including your home, and that can be a 1/10 interest, 15 ways divided in a tiny piece of, lake property or farmland that you think is worth nothing. Courts don't care. It's real property. It's got to be probated, all right? So think about those 4 things. Finally, the lesson to learn from Prince is that if you die without an estate plan, Your family will spend years in court while your assets are drained. And meanwhile, there's upkeep, there's taxes, there's insurance on these pieces of real estate. And you have to continue to pay for all this property while the case is being litigated in court. Okay, so until that judge, if it's uncontested, you might get it done in 2 years if you're lucky. If everybody agrees, it's 2 years that you cannot sell that home or any of the real estate, because the judge needs to close the probate case and then can guide you on what you can do with the property. So your hands are really tied until the case is closed in probate. Why do we like trust so much? We like trust because it avoids all of that conflict that we just spoke about, right? There's absolutely no court involvement. It's handled privately. This means that when you pass away, it's going to be as simple as a couple of transactions in a law office or even within your own home, as opposed to this big court action that's public that anybody can find out about. It's handled privately. There's no court involvement. Your assets are just going to transfer seamlessly from you to your loved ones, okay? Whoever you've designated as your beneficiary of your estate in your trust. It protects your assets. It protects your assets from predators, from opportunists, judgments, bankruptcies, whatever you put in your trust. Those assets, it's as though you've just wrapped them around and around in bubble wrap, and now you're protecting them, from all of these different things. And finally, you can make it happen really quickly. Forget about 2 years for an uncontested estate. Forget about 4, 10, or 20 years, if you're Anna Nicole Smith, where this thing is going to be drawn out in court. This is going to happen almost immediately, okay? And with little involvement. Aha, the king of pop, Michael Jackson, my very favorite concert. It was fantastic. I barely remember it. I was so young, but it was my first concert. My mother took me there, the bad concert. Man, was it awesome. But the king of pop, even the king couldn't get it right. He came closer. He came really close. He had a trust, you guys. He was able to hire the best attorneys to create a trust to protect all of his assets. And he sang the song, I'm bad, but he was bad at follow through, because even though he created a trust, what he failed to do is he failed to put his assets into the trust. So a trust is a lot like a treasure chest. Ooh, that's a lot to say. A trust is a lot like a treasure chest, okay? But they're useless if they never get funded. What good is a treasure chest if it contains no treasure? It's no good. The same thing with a trust. If you're Michael Jackson, you create the trust, but you never actually retitle your assets into the trust offers no protection. It's as good as not having one. So the lesson to learn from Michael Jackson is that failing to put your assets into a trust is equivalent to not having a trust at all. So unless that trust is funded, it does nothing, and your estate will still go to probate court. So that's what happened with Michael Jackson. His mother, on behalf of the estate, had to bring an action in probate court and convince the court that, in fact, Michael Jackson's intentions were to get these assets into the trust, and therefore the terms of the trust that he created should dictate the payout on his estate. And that didn't come easy, and it was expensive. Kobe Bryant, we love this guy, don't we? Let's see here. All right, Kobe Bryant. Kobe Bryant, actually, you know what? He probably did the best job of anybody in preparing his legacy. He and his wife, VANESSA, they did proper estate planning. They, in fact, created a trust, and they were able to fund that trust by retitling assets into it. The only problem, I'm going to give him an A- actually, because he came so close to getting it right. The only problem is Kobe's attorneys who drafted the trust were, in my opinion, just a little bit shady. And you do have to watch out for shady lawyers. And, they were like, this guy's got a lot of cash. He's a high net worth guy. Let's make sure he has to come back to us and we can actually get some more fees out of him. So what they did was, when they drafted the initial trust, Kobe and his wife, I think they have 3 kids. Let's just say they had 1. I don't remember if it was 1 or 2 when they created the trust, but when it was created, they were not finished having a family. So all the children were not yet born. And these attorneys used language that would only allow distributions to the 2 living children. So the 3rd child, or the last child who wasn't born yet, was not included in the trust. And you have to watch out for attorneys who do this, because you need to be asking your lawyers, what are some stages in life that would require me to come back to you and make some changes to my legacy plan? What are those? And what will that cost me? And in this case, they set it up so that Kobe and his wife, with every child, would have to come back and actually name the name of the child with every birth. And that's frankly ridiculous. Just get it right the first time. I always include language that says, as long as it is a child of the marriage, that child was intended to be included in the trust and treated as though they were born. So my clients can have 25 children and they can hire me before they even have their first child, and the trust is still going to stand, and they're not going to have to come back and pay me more money for every child that they have. So unfortunately, when Kobe passed away, they had this child who was not named in the trust. And so they actually had to seek permission. Miss Vanessa had to seek permission of the court to allow this new child to be treated as though she were a beneficiary, and that it were Kobe's intentions that she would be treated just like the other children. So the lesson to be learned from Kobe Bryant is research your legacy lawyer. Make sure that they're a specialist. If they're also doing, DUIs and divorces and bankruptcies, and they know how to do a will, that's a red flag. You don't want to go there. Find a specialist. Make sure that they also practice in probate court. There are too many lawyers who will tell you all you need is a will, and then you find out, how the hell do they know? They've never even stepped foot in a probate court. What they do is, when someone comes to them and says, hey, you drafted the will and now I don't know what to do with it, they send them to somebody like me, who's a specialist who has to go to probate court. Or they set it up knowing that the matter will have to go to probate court and be administered, and then they'll put a provision inside. This is another shady thing lawyers do. They'll put a provision inside that will saying that you, as the settler of your estate, are agreeing that your beneficiaries, when you pass, your personal representative, your executor, will go back to that law firm and have this administered. Again, another opportunity for them to suck more money out of you, okay? When it all could have been avoided up front. So research your lawyer, make sure they're a specialist, make sure they practice in probate court. Ask them, again, what changes to your estate plan they should anticipate throughout the course of their life, and will that cost any additional money? All right, so you might be asking yourself, if there are shady lawyers out there, why don't I just do it on my own? I'll just have a DIY estate plan. I mean, there's LegalZoom, there's Legal Shield, there's all these online options. This is why, because Supreme Court Justice, this is the highest ranked lawyer in our country, okay? The Chief Justice of the US Supreme Court, Warren Berger, did his own legacy plan. He created his own will. After all, he's an esteemed attorney, arguably the most esteemed in the nation at the time that he did this. But what did he do wrong? These guys, they're Supreme Court justices, they're incredibly bright, some of the brightest. But when they are making decisions regarding cases before them, they have a team of the smartest lawyers who are working as their clerks to do research and become specialists in all of these areas that are the nature of the cases before them. He didn't have all these specialists who were legacy planning attorneys to help him with his do-it-yourself will. He just took it upon himself to do just as much as he thought necessary. Well, what the problem was he didn't do enough. He didn't know what he was doing. So he actually ended up draining down his estate by, I think it was $187,000 that was lost from the estate, where had he hired a specialist to do it for him, he really could have gotten it right. But he made that mistake. So, if he can't get it right, odds are most of us can't, right? Without a specialist. And I always tell my clients, hey, going to a non-legacy attorney is like going to a dermatologist for a brain tumor. It makes no sense, okay? Everything is so specialized these days. You gotta go to a specialist. And you know, for some clients, for a lot of my clients, my high net worth clients, that means hundreds of thousands of dollars in tax savings that they didn't even know existed. So when I'm pushing a piece of paper with a figure on it across the table from a client, and I calculate the numbers and I say, the number is $214,000 that you can either pay to the IRS when you pass, or if you take action today and you work with me, we can cut that bill in half, and then that amount of money goes to who you want it to go to, your loved ones, your family. You want to write a check to the IRS or you want to write a check to your loved ones. It's up to you. But most of my clients don't even know, because they've never sat down with a specialist, that this is an option available to them. So the lesson to be learned from Chief Justice Warren Burger is that there is never, ever, ever a one-size-fits-all estate plan. Everyone's goals are different. Everyone's family dynamic is different. So if the Chief Justice can't get it right, you probably won't either. So don't rely on templates or an attorney who doesn't know your individual needs, your goals, and your family dynamic. So a little bit about me, why I'm able to talk about these things with such confidence. I am a 15-year asset expert, and in fact co-authored a statute on asset protection. I'm an award-winning legacy lawyer, and I have received accolades by both colleagues, but also, and more importantly to me, my clients, who give me 5-star reviews over and over. And I'm a published author on The Ultimate Guide to Protecting Your Family, and that is available on Amazon. More importantly, my personal journey brought me to where I am today. I don't know where to put this. How about right here? Sometimes, the reality is that sometimes people we love leave us too soon, and they do that unexpectedly. And as a collections litigation attorney who specialized in helping my clients, which were banks, credit card companies, financial institutions, and businesses, go after assets, I would help them discover assets, and then I would attach legally to those assets to pay down a judgment that my clients had received. I was really, really worn out. I was tired of litigation, and suddenly and unexpectedly, I lost both my brother and my best friend in a matter of months from one another. They were both in their mid-30s. It happened to both of them really unexpectedly. It was heartbreaking, and neither of them had done any estate planning because they were young, right? And you know, they luckily were not married, did not have children, but it didn't affect the fact that it was a mess for both of our families to clean up, a huge mess. And I was personally involved in guiding both of our families through this probate madness. And I saw how the decisions that needed to be made about the distribution of assets, everything from my brother's home, are we going to flip it? Should we just sell it as is? To my friends, she had sports memorabilia that were important to her, and she had family that was fighting over who was going to get that. In a time of grief, the last thing families need is conflict. They need guidance. They need someone to give them a blueprint for success. Let them know what your intentions are, who you wanted to have these things. And this was sort of my life's journey led me to this moment where I gained clarity, and I realized that as an expert in asset discovery, I could also be an expert in asset protection. And so now I dedicate my entire practice, and have for 6 years, to doing nothing other than working with families to make sure that their assets are protected and keep their families tight during a time of grief when they need each other most. Princess Diana. Princess Diana provides a great lesson to us. She had a huge heart. We all know this. She loved her boys. But the problem with Princess Diana is she had this beautiful legacy plan that was created by her esteemed, team of lawyers. And she decided that she wanted to make some additional gifts to her children, her boys. And so she did that by just kind of writing a letter to them, like a true old-fashioned letter. And in doing so, she made some contradictions in that letter from what her estate plan read. So this created a lot of conflict and ultimately led to litigation. So the lesson to be learned from Princess Diana is that don't ever, I always tell my clients this, don't ever cross out, don't even dot an I, don't make a spelling, a grammatical change to your estate plan, your will, your trust. Don't ever edit or alter your estate documents in any way because you could nullify them, meaning they're as good as non-existent, all right? Don't make a list like Princess Diana did that contradicts your will or trust. Everything needs to flow nicely together to avoid litigation, all right? What Princess Diana did was create just a beautiful invitation to litigate and go after her estate, okay? So this is a great lesson to be learned, and this goes to everyone, regardless of your wealth. Finally, Bobby Christina and Whitney Houston. What a tragic story this is. Whitney Houston, our queen of pop, on top of the world in her day. And the figure, depending on who you ask or at what point during the administration of her estate, we're talking about her daughter, Bobby Christina, inherited about $20 million roughly upon Whitney's passing. And this is just so tough because this is a big, I feel very strongly when I'm working with families about creating a recipe for success for their children, their young children or their soon-to-be children. Because if you create a windfall situation, which is what would happen if you were to pass and you have children who are minors and you had not created a trust, they are going to inherit by law a windfall of money. And that can be as early as 18 years old. All right, and in Bobby Christina's case, I believe she was 21 when she inherited all of her money. And Whitney did create a trust, and she did put ages and stages on Bobby Christina's inheritance. She was going to receive her inheritance at 3 different ages. And so she received 10%, so about the equivalent of $200,000 at age 21. Now, I don't know about Bobby Christina, but for most 21-year-olds, $200,000 is a serious windfall. And a windfall can prevent someone from going to college, from following their dreams. It can be a recipe for disaster, as it was for Miss Bobby Christina, as we all know how that ended. So the lesson to learn from Whitney Houston is don't set your young children up for a windfall. It can derail their future. Instead, I recommend you use ages and stages for beneficiary payouts. And in addition to that, some of my clients are putting in spendthrift clauses. Another thing I like to do is use a lifestyle disability clause that prevents any beneficiary from receiving a payout in the event that they are going through a lifestyle disability. And that can include a divorce, a judgment, a bankruptcy, an addiction issue, a gambling issue. And all we do is we say, hey, get your life back on track. And once you can prove that you're back on track, you're going to be entitled to that inheritance. But until you're there, we are not going to give someone who has a history of drug addiction this huge payout of money. It's not good for them. We all know that. We know that. Another thing I'm seeing that is really creative that we're doing with a lot of our high net worth clients, they want to see their children succeed. And so they're doing a match dollar for dollar. So for every dollar you earn, we will match that. So in other words, it's not just a payout, but instead of, you know, you make $100,000, that's fantastic. Now you'll receive $100,000 inheritance. So it incentivizes them and sets them up for success. Some other considerations are incapacity. We talked a little bit about J. Howard Marshall, Anna Nicole's hubby. You need to be thinking about things that can happen. Accidents can occur. We all like to believe that we're invincible, but you look at Kobe Bryant, you know, very young. He was in retirement, but still so strong, very healthy. The unexpected does occur. I talked about my brother and my best friend within a matter of months in their 30s. Just make sure that if you've got loved ones, you're leaving them with a blueprint for success and not a huge headache. You work so hard for your legacy. You want to make sure it goes to the people you love, right? And not the government or a bunch of opportunists. You may have charitable considerations. Maybe you want to create a charitable trust. We also use irrevocable trust. Sometimes we've got clients who have disabled children, who have special needs or supplemental needs trusts. These are all different forms of trust that we can use to create a lasting legacy. So you guys, I want to thank you for hanging in there with me through these celebrity screw-ups. Hopefully you're able to identify them, and it's got kind of a spark going in your head where you're thinking about all of the things all the mistakes that were made that hopefully resonated with you and have you thinking about the legacy that you want to leave for your loved ones. I encourage you to reach out to me with any questions you might have. You're welcome to book your legacy building day and actually sit down with me or a Zoom call with me. Find out how we can make a legacy work for you. Feel free to email me directly. I answer my own emails. It's lisah@legaltransparency.com. You can check out my website at prosportslegacylawyer.com. Thanks, guys.